Hello, everyone. Hello, everyone. Thank you very much for joining us for this 27th annual Federalist Society Faculty Conference. I am Lee Liberman Otis, and I think I know most of you, although maybe not all of you. I'm now one of the two executive vice presidents of the society, and I sort of basically oversee the faculty division, but I should say that my colleague, many of my colleagues who are here have done a lot of the work on this. And let me point out my colleague Anthony Deardorff, who is the director of faculty programs, who's really overseen this, along with my colleague Rory Smith, who is somewhere over there. And we're also joined by our new colleague, Katie McClendon, who will be the Director of Faculty Relations. I mean, she's been my colleague for a long time, but she's joining the faculty division as the Director of Faculty Relations. And several other key staff people are here, but I'm not going to take up more time putting them out right now. I do have one exciting announcement I want to make before I turn things over to Kristin to introduce our panel. We are going to be launching a new $10,000 prize for the best piece of originalist scholarship in any for 2026, I guess, and it's going to be called the Meese Prize in honor of the former Attorney General, who obviously made important contributions to bringing attention to originalism as a way of approaching the Constitution during his term as Attorney General, and it's made possible by the co-chair of the board of directors of the Federalist Society, Steve Calabrese. We'll be posting something about this, and I'll also send an email around to faculty about this, but nominations for this year are due March 15th. So did just want to let everybody know about that. Without further ado, now let me turn things over to our distinguished moderator and my longtime friend, Kristin Hickman of the University of Minnesota, who will get us going.
Thanks so much, Lee, and good afternoon, everyone, and thank you so much for joining us today for what I think promises to be a really fun debate and a rollicking good time discussing the removal power and whether the president has the indefeasible power of removal under the U.S. Constitution. Questions surrounding the ability of Congress to limit the president's removal power have been fascinating legal scholars for decades. Until recently, I think it's fair to say that the Supreme Court jurisprudence on the topic has been both inconsistent and muddled, at best. Since the Free Enterprise Fund case in 2010, the Roberts Court has been chipping away case by case at Congress's ability to impose statutory removal power restrictions, but all the while has maintained that it was respecting past precedents. The current Supreme Court term presents us with not just one, but two critical removal power cases. Trump versus Slaughter, which the court heard in the fall, concerns the legality of President Trump's removal of Federal Trade Commissioner Rebecca Slaughter from office. After the Federal District Court ordered her reinstatement, The Supreme Court stayed that order and agreed to consider both whether the statutory removal protections for FTC members violate separation of powers principles, and also whether a federal court can prevent a person's removal from public office. The Slaughter case is particularly pivotal because it squarely requires the Supreme Court to consider overturning its 1935 Humphreys Executor decision, which also concerned the Federal Trade Commission and upheld the same statutory removal power limits. But we aren't done there. Later this month, the court will hear oral arguments in the case of Lisa Cook, a member of the Federal Reserve's Board of Governors, whom President Trump seeks to remove for cause based on allegations of mortgage fraud. Notwithstanding those allegations, those who follow these cases recognize that the court may take the opportunity to address whether the president has the power to fire a Federal Reserve Board governor for any reason at all. And just last year, in a statement in Trump versus Wilcox, the court suggested that it might view the Federal Reserve differently from other agencies, calling it a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. So, with those two cases in mind, we turn to our question today, whether the president has an indefeasible power of removal. To address this question, I am joined by Aditya Bamzai, Professor of Law at the University of Virginia, and Andrea Katz, Associate Professor of Law at Washington University in St. Louis. We will begin by opening remarks from Professors Bamzai and Katz, followed by an opportunity for rebuttal from each before turning to questions. Professor Bamzai.
Well, thank you so much, Professor Hickman. Thanks to Professor Katz for being here with me. Thanks to the organizers for including me. Thanks to all of you for being here to talk about this, to my mind, fascinating and consequential topic. Since I'm going first, I'll quickly describe the contours of the debate on the topic, and then, as I understand them, as precisely as possible, describe the sources of disagreement about the meaning of the Constitution and its history. So let's begin with a big picture, bird's eye view. Seems to me that everyone can agree that the federal Constitution creates a unitary executive in one sense. And that is because at the Constitutional Convention, the question arose whether to give the executive power to a single individual who would fill the office of the president, or to have several executives or an executive council. And arguing in favor of the former, James Wilson said that, quote, a single magistrate would, quote, give most energy and dispatch and responsibility to the office, and that, quote, unity to the executive would be the best safeguard against tyranny. But the latter notion of a plural executive was by no means outlandish, because many states had and continue to have plural executives, and some even viewed the Congress under the Articles of Confederation as a plural executive authority. For example, Thomas Burke, a delegate from North Carolina, had described the Continental Congress in 1779 as not a legislative body, but a deliberating executive assembly. The idea of a single executive won out at the convention and made its way into our Constitution. So at least nominally, in form, there is a single executive atop the executive branch at the federal level. The question then becomes whether the Constitution means for there to be a single executive in both substance as well as in form, and if so, what the contours of that substance might be. And in our modern jurisprudence, the question of substance has depended largely on these cases that Kristin just described, on whether the president has the power to remove subordinates within the executive branch. So to start with a somewhat fanciful hypothetical, imagine that Congress were to cleave off a portion of the executive branch, and take your pick, but let's say the State Department, and render its head not answerable to the president, but rather, let's say, the Senate Majority Leader or the Chief Justice. Chief Justice Roberts gets to run the Department of the State for life. Would that be constitutional? And if your intuition is no, that suggests there are some implied limits on how Congress might structure executive agencies at the federal level. And then if you grant that premise, that alone indicates that there is an indefeasible removal power of some kind and some scope. Because by my understanding, the term indefeasible contrasts with a default rule that can be overturned or annulled by Congress at its discretion. And so when it comes to the resolution before us today, I would say, yes, there is an indefeasible removal power of some kind, and then we can debate the circumstances. So the question becomes, where do those implied limits come from, and what are their contours? And here, the first clause of Article 2 of the Constitution vests the executive power in a president of the United States. Article 2 then does go on to give various other specific powers, impose duties on the president, the appointments power, the opinions clause, the power to take care of the law, or the duty to take care that the laws are faithfully executed, these being among the powers that are related to this topic. The question has always been whether the first clause, vested executive power, confers some authority, the removal authority, in addition to the clauses that follow. And let me briefly now turn to the types of history that scholars and courts have relied on in seeking to understand these provisions. The complexity here is that the meaning of the executive power vesting clause was much discussed in the early days of the federal government. Indeed, literally everyone who had an opinion on law seemed to have had an opinion on the president's authority to control the executive branch. And you can find treatments of the issue from people like Alexander Hamilton, John Marshall, Daniel Webster, James Kent, Joseph Story, Benjamin Curtis, the dissenter in Dred Scott, later the lead attorney for Andrew Johnson in his impeachment trial, among many others. And that's why the issue remains absorbing for academics to this day. I truly could not do justice to the various nuances in the short time available to me today, so let me sketch out the contours. The contours are that the very first debate in Congress that engaged over the meaning of the Constitution was about who controlled the executive branch. The debate arose because a draft bill that was before Congress at the time contained language granting the president authority to remove the heads of the Department of Foreign Affairs, which then prompted dispute over where the Constitution lodges the power to remove, if at all. Some, like Representative James Madison, argued that the executive power vesting clause conferred a power to remove on the president, which Congress could not modify by statute. Others argued that because the president appointed with the advice and consent of the Senate, removal could only occur with the advice and consent of the Senate. Still others said that the Constitution was silent on the topic, leaving the entire matter in the hands of future Congresses. Scholars continue to debate the import of this debate, which has come to be known as the decision of 1789. But one aspect of it is undeniable. It was a close debate with a tie vote in the Senate that had to be broken by the Vice President, John Adams, who adhered to the perspective that the executive power vesting clause conferred removal authority on the president. The question then arose during the Jefferson administration when issues relating to removal and the justices of the peace in the District of Columbia made their way to the courts, famously in the case of Marbury versus Madison that has some dicta on this topic. Again, it arose when Andrew Jackson dismissed the Secretary of the Treasury for failing to initiate a funds transfer in order to weaken the Bank of the United States. Again, it arose when Congress impeached and almost removed President Andrew Johnson for seeking to replace the Secretary of War during Reconstruction. This last episode was based on a statute known as the Tenure of Office Act, which Congress had enacted in 1867 to limit President Johnson's authority to remove officers without the Senate's advice and consent. And despite presidential objections, that statute remained on the books for 2 decades until Congress repealed it in 1887. At which point, Congress the very same year created the Interstate Commerce Commission, often thought to be the first real independent agency, subjecting its members to removal for inefficiency, neglect of duty, malfeasance in office. And the following years then saw the creation of other such agencies, the next major one being the Federal Reserve Board of Governors in 1913 and the Federal Trade Commission in 1914. So what to make of all this? I'll just wrap up here and then move on, and then we can hear from others. One perspective, which I tend to agree with, is to say that the better interpretation of the Constitution acknowledges a presidential authority to remove that Congress cannot take away by statute, that this was the best interpretation of the text, and early debates, and it was the prevailing practices until the Civil War era, at which point the Tenure of Office Act interrupted the general approach. That's the perspective that you see articulated by, say, Chief Justice Taft, in the Myers case, or Chief Justice Roberts in more recent cases. Another approach, of course, is to dispute this narrative, to say that there are complications, and to be sure, I've not been able to get to all of the nuances that we could discuss in this short introductory remarks. To say perhaps for policy or prudential reasons, the history should matter less, practical concerns should matter more, but I'll stop right there and be happy to field any further questions.
Professor Katz. Professor Katz.
Okay. Thank you all for having me as an interloper. So this is a beautifully run event, and I'm happy to be here. Okay, I'll start with what I hope is not a non sequitur. Congress does not hide elephants in mouse holes. So it was famously Justice Scalia who wrote this, of course, and his point was that context matters when we interpret text, and we have to be careful about finding things in the text that simply aren't there. I think you can see where I'm going with this. So in President Trump's current term, he's used the removal power to fire, by one count, 300,000 employees. And quite importantly, the president has used the firing power to threaten, coerce employees, to tell employees to ignore statutory mandates, even to empty out whole agencies. Under our Constitution, of course, it's Congress that can abolish an agency. Has Congress abolished the Department of Education? Obviously not. Which tells us that the president is using the firing power to remake the shape of our government, to move the law beyond what the statutes on the books say. Is that behavior comprehended within the concept, the executive power? I think only, and let me borrow one more time from Justice Scalia, in the same way that the French Revolution modified the status of the nobility. Okay? So I think we should be very honest about whether any of the behavior that we're seeing currently is originalist. An unrestricted presidential removal power, this is my argument, this is an elephant smuggled into the mouse hole of Article 2. And I think the truth of that fact has never been better proven than by the Trump administration. So does our Constitution silently grant powers of this magnitude? I don't think it does. Does our Constitution silently grant powers at all, for that matter? Our federal government is one of limited and enumerated powers. And yet somehow we have a president who possesses implied powers to change the system. This can't be right. Especially not when the Constitution lists several powers that the president does possess, including the power to receive ambassadors, to recommend bills, to ask department heads for advice. Why would the Constitution grant, in particular, that last power if the president can simply fire all officers? He could just say, give me your written advice or I'll fire you. Turning to the convention at Philadelphia, the delegates didn't speak of removal. Does that mean that all of them understood removal to be inherent within the executive power? Perhaps. But another explanation is they just didn't think about it. The convention met in May, but if we follow the record, it wasn't until 2 weeks before the convention adjourned in September that the president gained a share in officer appointment. So it's only after the framers come up with the scheme of how the president is to be elected, obviously through an electoral college, that they moved the power of appointment from exclusively the Senate to being shared with the president. And I think from that episode, we can derive the point that the framers were comfortable mixing and matching powers according to the balance of power they wanted to achieve. In other words, they cared less about whether the president possessed a power as an inherent matter than what powers they wanted the president to possess. Otherwise, our president would have possessed the same bundle of powers that the English king did, right? Things like the federative power, which includes foreign affairs and treaty making, and clearly that's not the case. If we turn to the King of England as a model himself, some delegates did have the British monarch in mind as a blueprint. Professor McConnell has shown this brilliantly. Yet, ironically, not even the British monarch possessed an unlimited removal power. In 1765, William Blackstone tells us that there are 4 types of public offices under English law. Those with tenure during pleasure only, with tenure for a term of years, for life, or offices that were inheritable by your heirs. So if you were lucky enough to have the for life or the inheritable type of office, not even the king could fire you. So again, consider the implication from our side of the Atlantic. We're alleging that the framers silently and by implication gave our president greater power to fire than even the King of England possessed, 12 years after the revolution. I don't think so. Another model for the president that we know was the state constitutions. At the time, these didn't give the governor, removal either in the main. So New York, 1777. New York's constitution specified that officers held their positions during the pleasure of a council of appointments. So this was a 5-man body on which the governor had a single vote. Massachusetts specified that officers' tenure, quote, shall be expressed in their respective commissions. So in other words, who can fire the officer? Don't ask the Constitution. Look at the statute that creates the office. That's the Massachusetts rule. Pennsylvania, famously hostile to the executive power, actually let their legislature fire. So the point, I think, from this very brief survey is that states could clearly contemplate separating the removal power from the executive, from the governor in those cases. And in point of fact, secondly, the practical result of a system like this is that administration was highly stable early in our republic. Mass removals simply didn't happen, even under powerful governors like George Clinton of New York. People often held their offices for decades. You were far more likely, in other words, to die in office than you were to be fired. And this was true in a lot of the states. It's true, this is work that I'm doing right now under our federal constitution as well. Our first 5 presidents fired a total of 76 civil officers across all of them. In 1802, the federal government included 3,905 civilian personnel. So clearly, removal was not that important for presidents as a tool of supervising administration. Okay. Turning to Congress, did Congress think that the president had a sweeping removal power? Professor Bamzai has already very eloquently laid out the contours of the decision of 1789. It's been taken by many scholars as admission by the first Congress of what was already there all along, right, a presidential removal power. But in fact, the decision of 1789 is really a passionate 5-day debate that divided legislators into at least 4 camps. In fact, I'm going to quote James Madison, who writes in a letter to Tench Coxe that June. He writes, "A very interesting question has grown out of the silence of the Constitution with regard to the power of removal from offices." And he says, "And out of this silence, 4 constructive doctrines have arisen," and he meant on the floor. So you had legislators who believed that removal of officers could be done by impeachment only. This would have been a very cumbersome system. Those who believed that removal was shared, right, symmetrical to the appointment power. Those who believed that Congress could dispose of removal power through statutes, and those who favored the presidential option. But I think the point is this: why would Madison call this an interesting question in June 1989 and admit that the delegates were split on the question if the Constitution had already decided it 2 years before? Besides, looking at the debate of 1789, if you count the votes and actually code legislators by what they stated, what they said themselves to believe, the presidential option has maybe 60. In other words, Congress was divided. Madison himself later admitted when Congress was designing the Treasury that tenure could vary by the job. And so when Congress is debating the office of the comptroller, Madison says there may be strong reasons why an officer of this kind should not hold his office at the pleasure of the executive branch, okay? Again, this is a sense that even Madison, the presidentialist, believed that removal could be determined by statute as opposed to a constitutional question. And if we look at early statutes, we can see that Congress treated removal as something that varied based on the job. So Congress, for one thing, created officers where the president couldn't remove the officer. We might discuss this later. Multi-member commissions like the sinking fund. featuring officers who could not be removed. Okay. Congress also created jobs that would expire, and they did this a lot when it came to the military or customs officials where they wanted the numbers of officers to shrink and grow. So this is Congress giving itself a lot of power over the number of federal officers. Congress also created what myself and a couple co-authors are calling automatic removals for officers engaged in the money supply. So for instance, the Tariff Act of 1789 says that any officer of the customs who shall take or receive a bribe and thereof be convicted would be, quote, forever disabled from holding any office of trust or profit under the United States. So I think the point is that corrupt officers under these schemes aren't fired by the president, they're fired by judges. The framing generation looking at these statutes didn't see removal as necessarily executive. They decided removal, right, these are Congresses, decided removal based on the outcomes that they thought were best. And so different officers get different arrangements. Kind of coda to the story, I'll wrap up here. Professor Bamzai already mentioned these sort of swings of where removal becomes controversial. I think that's absolutely true. In 1833, President Andrew Jackson starts firing officers who refuse his orders on the bank deposits. And at the time, Justice Joseph Story is writing his commentaries. He says that Jackson was disrupting a harmonious system. So what is that system? I think the system is that this is not constitutional liquidation of the presidential removal power. It's a negotiated political settlement. Congress tolerates that the president is in the main, by far the majority of cases, the actor who fires, provided that power is not abused. So again, I see this as a political settlement, which we see play out through statutes. Again, my sort of back to the constitutional point, the framers were geniuses. I don't think they had a crystal ball on this one. The text contained plenty of silences, and I think the removal power is quite a massive elephant for us to find in the holes of the Constitution. Okay, I'll stop there.
Rebuttal?
Well, thank you. Yeah, let me start by saying, the pro and con on this side of the debate gives you a sense of why it has been an endlessly fascinating debate over the course of a few hundred years. I think this is, it's not an instance of us finding an elephant in a mouse hole after 200 years. And the evidence is that there were these debates, and this issue did come up over time, including in the first Congress, where various representatives, including Madison, thought that there was appropriately interpreted a removal power in the Constitution. So let me just think about a few of the topics that Professor Katz raised and throw out a few ideas on them. One, with respect to the convention. Of course, we have notes from various members of the convention, and the notes suggest that there is this sequence of events with respect to the creation of the presidency. And I think the way that I might think about it is that at an early stage in the proceedings, Madison, when the appointment authority is being debated at the convention, says, well, actually, this might just be implied by the executive power vesting provision that was on the table at the time. It was phrased slightly differently. But Madison says appointments might actually just be implied from executive power. And removal and appointments were clumped together in the minds of many of the folks who were writing the Constitution. And so that kind of explains why what actually happens is the appointment and removal authorities might have been thought to be together, and the appointments authority gets to be associated with the Senate over the course of the convention. And then the folks who have a perspective that the Senate must be involved in removal as a matter of constitutional law, if one thinks about it, their perspective is actually doctrinally kind of close to the folks who have a perspective that the president ought to have a removal power, because their view is that removal follows appointment, and it's the Senate and the president appointing together, whereas Madison's view was it's the president appointing with the advice and consent of the Senate, and that's why the removal power did not, when we inserted in the advice and consent authority, get shifted over to the Senate as well. So, okay, that's some sense of like how the convention notes can be understood. I do think that with respect to the states, as I mentioned, Professor Katz did as well, there was variation. But another interesting point on that is that in the Federalist Papers, you will find, I think it's in one of Hamilton's papers, a description, it could be Madison, but we'd have to check on that, a description of how the states, when they confer appointment authority on different organizations, like say the legislature or a council, what they are doing is lodging a part of the executive power in a plural body. They're thinking of it as a plural executive. This is the language that is used in the Federalist Papers and elsewhere. I also think that when we look at the Comptroller of the Treasury debate, I interpret that a little bit differently. I would think of that as Madison suggesting that the Comptroller of the Treasury could be thought of as a judicial officer having judicial type functions and perhaps be given some sort of like good behavior tenure. But that is something that, you know, in order to really drill down on, I suppose we would have to get into the weeds of the language that he's proposing at the time. Finally, just let me make a couple of remarks at the very end. One is about the practical implications of this. I don't think the Department of Education issue really stands or falls on the removal power question, and that is because there's a distinction between who controls the executive branch and the substantive authorities that the executive branch has been given and their scope. So I'm not expert on whether the Department of Education has certain authorities that must be conducted by a separate department known as the Department of Education. That's an issue that might be separate and apart from this one, but it just seems distinct from this question, which is who does control the Department of Education at the end of the day? And I refer back then to the implication from the perspective that there is no removal power. The implication is that the Chief Justice could control the executive branch with life tenure. If there is no removal power, that's a statute that Congress could lawfully enact. And that's actually just not a position that any of the Supreme Court justices have taken in any of their opinions up to this point. So that does leave us, this is the final point, with the question of what to do when, truthfully, we do have a sequence of 200 years where people did take different positions on this. That did happen. Daniel Webster, Henry Clay, John Calhoun, they were on one side of this issue. Andrew Jackson was on another side of this question. And so one might look at that and then take the position that anytime there was a debate, that means that there is no constitutional settlement on a legal question. And I don't really have that position generally with respect to how statutes are interpreted or the Constitution's interpreted. And I don't think any of the Supreme Court justices really do. And I'll just throw out a few other things that were debated hotly at the time. I don't know, like other authorities that should be given to judicial officers, famously debated in a sequence of episodes that end up in Hayward's case. So would we say now, and this is related to my Chief Justice hypothetical, that various authorities could just be given to judicial officers because this was a debate at the time? Or the Alien and Sedition Acts, they were debated at the time. Does that mean ipso facto all of the provisions of the Alien and Sedition Acts are constitutional at this time? And what does that do with provisions that actually were never debated? How about, say, like the Fourth Amendment, which just seems to never really come up over the course of decades? Do we have the same, because it's silent, there ought to be no constitutional meaning to these provisions perspective? And so that's why I would think that this issue, it actually is a little bit different from the Fourth Amendment in that lots of people weighed in on it, and we're still now in our present day able to make the best arguments based on the resources that we have before us.
Rebuttal.
Or applause?
Or applause.
Okay. Okay. I'll just proceed. I mean, it seems that there's much that we agree with. Let me just try to pick up on a few discrete points, and then we'll allow the invitation to struggle to continue through the Q&A, I guess. I think that, so let me start with the convention at Philadelphia itself. Again, I think empirically it is, or interpretively, it's not a wise move for us to take the question as settled when, again, the framers spent so little time debating the issue of removal. It may have been that many believed that the removal power was symmetric to appointment, right? We know that some of the framers sort of initially viewed the Senate as something like a governor's council, like some state constitutions did have. And so I believe that some of them thought, initially you're vesting appointment and removal with the Senate, later you're splitting it. They adjourned without resolution on this topic. So I think that for some of the framers, they believed that removal was to be split between the two. Now, I also personally believe that that would have been a really cumbersome system. I think in most cases, it is best for the president to have the power to fire officers, right? And if you look at the debates of 1789, the text of the floor debates, I think many of the delegates, many of the representatives' interventions follow that argument. It will be very bad for the nation if we have fights between the president and the Senate anytime we need to remove an officer. But again, I think that's an argument based on utility, not an argument based on constitutional necessity. When the delegates adjourned, I think it's fair to say there was not consensus on what removal would look like. The historian Forrest McDonald, I always teach out of his account, he says many of the delegates were tired and irritated and hot and wanted to go home. So again, I think the best interpretive rule coming out of the Philadelphia Convention is the question was left unsettled. And again, when you look at the debates in 1789, there were some, like Madison, he would have known, he had quite a hand in writing the Constitution, who felt that the language was self-evident, that the executive power contained within it removal. But there were many who didn't really know what was going on, right? Expressed doubts on what the text had actually said. And many of those who voted ultimately for the presidential alternative, again, I want to emphasize this, did this because it was useful for the president to fire, as opposed to having to tolerate an impeachment proceeding or inter-branch clashes every time we wanted to get rid of officers. And it brings me to a third point about the sort of arc of history. Professor Bamzai discussed a sort of landscape where 1789, if not 1787, settles this question, and then it is newly problematized after the Civil War. I think we can look at a more continuous history along the lines of what I ended with Justice Story commenting on Jackson. The vast majority of early statutes said nothing about removal. A project I'm working on right now, we've collected 400 statutes from 1789 to 1820. Only 90 of them said anything about removal at all. Silence, for the most part. And I think what that means is a significant amount of inter-branch compromise and cooperation. I think Congress and the president work together as allies. And I think the nature of the removal debate is such that it becomes topical when the branches fight. And so Andrew Jackson does disturb the settlement, and Andrew Johnson does disturb the settlement. And Chief Justice Taft and Myers, for whatever reasons he had, also believed that this was a pivotal moment to rethink the settlement. But this is to say, I think Congress, for the most part, early on, designed statutes to provide removal based on the outcomes that they wanted to see. And I know that we're going to talk a little bit about Slaughter and Cook as well. But the early framers were completely capable of understanding the notion that for certain sensitive functions, like managing the money supply, you didn't want political interference. They could contemplate creating independent officers this way. Last point I'm going to make, disagreement. As an interpretive matter, I think when we have disagreement about the existence of a constitutional power, the answer is the court should not butt in. These questions should be resolved by statute. If a statute ostensibly intrudes on the president's power, I think the remedy is there. The president should veto the statute. That's what I think. I don't think the president needs the Supreme Court to come galloping to the rescue. Okay, I'll leave it there.
Okay, with that, we are turning to questions, and I'm going to exercise moderator's prerogative to ask the first question. I always like that bit. Okay, so turning somewhat to the cases, you know, of course, one of the reasons we are focusing so heavily on all of the historical evidence is because at this present time, at least 6 justices on the Supreme Court claim to be originalists, or at a minimum are persuadable by originalist arguments employing this kind of historical evidence. However, those of us who follow originalism know that the justices don't all have the same approach to originalist inquiry. So one question that I have been contemplating in the face of all of this historical evidence is, how will the evidence play into, on the one hand, an originalism that is highly textually oriented, highly reliant on dictionaries, carefully parsing the text of the Constitution, whether we're talking about, obviously not necessarily explicit text, but at a minimum implied conclusions that we can draw from the text, versus an originalism that we've seen emerge more forcefully in recent terms that relies a little bit more loosely on history and tradition, let's call it. It seems to me anyway that we might get different answers depending on the originalist approach. And I'm very curious to hear your thoughts, Professors Bamzai and Katz, about how these different methods of originalism or these different approaches to originalism might merge with the historical evidence that you have outlined. Who wants to go first?
I'm happy to start.
Okay.
I'm not the most sophisticated practitioner of originalism, but I'll do my best. I think so. An original public meaning approach focuses on some of the ground that we've already covered, namely this question of the executive power as a concept and whether inherently it includes this sort of supervisory power of removal. I want to say that despite the fact that I've been arguing that there isn't an original removal power, the Supreme Court has, strenuously rejected my reading of the text. So an original public meaning approach to this question, again, sort of looks at the words, the executive power, and finds whether the president has to have this power to supervise and, if necessary, remove. So one version that this is cashed out, the president must be able to fire all officers because removal is inherently executive. I think Chief Justice Roberts, namely in the free enterprise case you mentioned, SALA law, has been driving at a narrower rule, which is that the executive power requires that the president must be able to fire all of those who exercise authority in his name. I think this is the phrase from SALA law. And so then the question becomes, is the officer in question, Slaughter in the FTC, Cook in the Federal Reserve, exercising the executive power? And so I think the original public meaning test is going to lend itself to line drawing about what sort of an officer everyone is. And then I think the history and tradition inquiry would be a little bit different. And this is partly why the work of Kristin Chabot and Victoria Nurse at Georgetown is important. Do we have a historical basis for independent officers, independent agencies like the FTC, like the Federal Reserve? Do we find analogs to those in the framing generation? And I think that we do. I'm not, per se, I don't necessarily believe that the court is going to view the history the way I do, but I think, as I've argued, there are examples of independent officers in the framers' generation. And so I think that's what a history and tradition inquiry would look like. But I will say, totally sincerely, I don't know, I haven't really seen yet in the presidential power debates whether there is a sort of divergence of original public meaning, reasoning versus history and tradition. And so I am, for one, curious about which way these cases are going to go.
Yeah, I don't know if I disagree with Professor Katz's bottom line. It seems to me that, in all likelihood, the court is relying on all of these sources of evidence, and we'll just see how the opinion writes out. I'm not a good predictor of Supreme Court opinions, and if I were, I would be making a lot more money than I make currently. So I do think that what the opinion might show, and more globally, is interesting in terms of interpretive theory, and this circles back to the theme that Professor Katz had started off with a few moments ago, is the question of implied authorities or implied powers under the Constitution. And so, for example, as we all know, there's a commerce power, but there are various other authorities that the federal government exercises pursuant to the commerce power, and we think of those as being implied, or implied from a combination of powers at the federal level. And in fact, the analogy between removal and implied authority to create the Bank of the United States was made by people at the time that these issues were being debated in the early Congresses. A second point of comparison in terms of like implied powers would be the judicial power vesting clause. We know in Article 3 there's a provision that says the judicial power shall be vested in the courts of the United States. Well, there are a whole host of like implied authorities that are thought to emerge from that provision. If they didn't emerge from that provision, there's no other provision in the Constitution that grants them, for example, the ability to issue binding judgments, to hold parties in contempt under some circumstances that's thought to be inherent, or to adjudicate private rights cases. These are all implied from that judicial power vesting clause in a similar fashion.
Okay, we have a microphone. If you would like to ask a question, I'd like to invite people to line up behind the microphone. While people are doing that, I have failed in a basic function of a moderator and got up here without a clock. So I'm going to ask, Anthony, would you mind signaling me, please, when we get to the point where we should take the last question? Thank you very much. Starting with Professor Fitzpatrick.
Thank you so much. I'd like to know what the implications are for lower level executive branch employees of each of your interpretations. You know, the civil service protections arose 100 years after the founding of the country. Are those protections unconstitutional as well?
I think it's a really interesting question, and it's one that the court will potentially not resolve in these cases, and will confront at some point in the future. Now, the way it's framed is about civil service protections, and civil service protections are thought generally to apply to what are believed to be employees of the United States and not officers, inferior or principal or otherwise. And the protections themselves might, and on this I'm not an expert, there are other people who are, be changeable by statute such that they are the types of issues that potentially would not be teed up like in the immediate future with respect to the constitutional question, like conceivably if the statutes just allow for reclassification of various employees. So with that aside, I think the question is getting at whether there are differences that could be perhaps made between inferior officers and principal officers. And the first debates, the ones that we talked about, did in fact focus on principal officers. And one of the sources that Professor Katz cited some time ago, it's actually interesting, and so I take this seriously. Justice Story's commentaries on the Constitution. During the Jackson administration, he says, the decision of 1789 decided this question with respect to removal, but that was only about principal officers, and it doesn't apply to inferior officers. So I raise that as a point to say that there were, in fact, authorities out there who have this hybrid position that distinguished between principal and inferior officers, and that would have to be grappled with at any future point if this issue does, in fact, get teed up.
Well, my position has been that the president can continue to exercise the executive power even in the face of independent officers. So the civil service doesn't give any problem for me. But I think your question is very important because Professor Hickman said before that the court's jurisprudence on this has been muddled, right? And I think what we do have right now are a couple different rationales playing out that would point in different directions. The executive power rationale is potentially very threatening to an independent civil service, right? Chief Justice Taft writes in Myers, 1926, which is very much a guiding star for the current court, that the president, in order to discern the public interest and execute the laws, must have the trust of his subordinates, and if anyone violates that trust, he must be able to dismiss them without delay. If the executive power requires supervisory and removal authority over everyone wielding the executive power all the way down, the president must be able to fire. Do I think the court will go in that direction? Probably not. So I've written about the Myers opinion, and I'm completely fascinated with it. We know from the drafting that that Justice Stone encouraged Chief Justice Taft to write an opinion that swept up the civil service, and Taft said no. And so the rule out of Myers, if you read it carefully, is that the president must be able to fire all principal officers, but not inferior officers. And so I think it's more likely that the court carves out inferior officers, but it remains to be seen. If they take the executive power, trust, and subordinates argument, the civil service is toast, and if not, they're insulated because they're inferior. But I think it's an open question.
One line I remember from the convention on this topic was that someone said the president should have a cabinet. And there was some agreement, I believe, at the convention. Oh yeah, he should have a cabinet. And they kind of seemed to know what a cabinet was because, you know, they'd been coming out of a British system that had a cabinet and it had a parliament. And, you know, they had, you know, judges who had lifetime tenure. And so my question, I think, is mainly for Professor Katz is, what, you know, you quoted from Blackstone, but I think that, you know, a British executive is going to be different than an American executive in that, you know, this is a democratically elected American executive. And that, you know, in Britain they have permanent civil servants, you know, they have judges who are not a separate branch. So does that affect your argument at all?
Can I just get you to, what do you mean by the cabinet? Like the fact that they considered a cabinet, you're suggesting that we shouldn't take much from the British precedent because we have such structural differences?
Yes.
Okay. Well, I mean, I think you're right. I guess a couple things there. I was quoting Blackstone on the idea of officers. And so my sense, I'm not an expert on the law of early officers. There are people in this room who have written about it far more in depth than I have. But I think we inherited this concept of office holding as a form of property, right? A super valuable thing, because in some cases you held the job for life and could even pass it to your son. I think we inherited it, and I think over the course of our history, it becomes easier and easier to fire officers. I think early at the founding, we see Congress come to the realization that we have a lot of inept, corrupt, too old civil servants, and we need to make it easier to fire. So I think you see several episodes where Congress legislates in a way that makes it easier to fire. But I think this shows America gradually evolving away from this British concept of office as a form of property. And as for the cabinet, yeah, I think you're right. I mean, I think that the Constitution, the federal Constitution, rejects a lot of what the state constitutions do. Professor Bamzai and Professor Prakash have written about this. So I certainly think they take their cues in a negative register from many of the state constitutions, but many of them did experiment with the council in this mode, kind of a British cabinet, a body of experts who would guide the president, but also who would act as a brake on the president. And I do agree that the Constitution strenuously rejected that model.
So if I could just add like two quick thoughts. The first is that by the time, you know, America's declaring independence and writing the Constitution, Britain as a precedent is not actually, I mean, we're dealing, it's an age of parliamentary supremacy. So Parliament really, at least in many aspects, can enact laws in any which way it thinks is appropriate. And that is a way in which our system departs from Parliament such that one can't just look at, say, for example, there were inheritable offices in England prior to American independence and say, well, there must have been some comparable notion that you know, the American founders had at the same time. In fact, some of the members who are debating the decision of 1789, they say, well, that's not our system. We live in a republic, not in a monarchy. We don't have inheritable offices.
Eric?
So I'm on the fence on this issue, and so I'm going to ask the hardest question I can to each of the two professors. So to Professor Bamzai, the reason I'm open and interested in the position you've taken, I'm hesitant about it because I would expect an originalist case for removal to be grounded in what executive power meant in English practice and any other relevant sources. And so I was hoping to hear a lot more about English practice and Montesquieu and international law treatises, and very little about the precedent of 1789. And I'm curious if you have any reaction to my predisposition. To Professor Katz, so I was very interested to hear the things you said about English practice in your comments. The part I resisted most was where you invoked the elephant and mouse hole canons. I would say that legislative power, judicial power, and executive powers are elephant holes. They are big reserves of power, and then so in Article 2, executive power is very, very broad, and it ought to be conceived as broad, and then things like the take care clause are specifications of a broader executive power. And I'm curious if you agree, if you disagree, and if you do agree, how that might affect your argument.
Well, notwithstanding that Eric went to Professor Bamzai first, I think it's Professor Katz's turn to start.
Oh, okay, great. All right, so elephant holes. I mean, I think that's important. Professor Bamzai mentioned Congress's implied powers, right? We all read McCulloch versus Maryland. I don't disagree that Article 2 is big. The framers wanted a powerful executive. I think we have to look, you can reject my idea that Article 2 is a mouse hole and removal is an elephant and still look at the historical practices of designing executive power in the states and, again, in the early republic. And again, if you look at this, people did not grant executive power as a residual whole. They parceled out things that, for example, the king had done and assigned them in different places. And I think this model makes more sense in terms of what the framers did. Obviously, a power that was granted to the president is granted constitutionally. But again, there is an absence of removal. And so again, despite the elephantine size of Article 2, I think we should resist to find removal there if the framers didn't put it there.
So I'll just say in response, this is a great idea for my next research topic. Perhaps what this reveals is a different methodological stress on different sources. And so I'm stressing the American sources that were developed around the time of the Constitution's adoption. And you're thinking of sources that predated that. And maybe one response I would have, which relates to my answer to the previous question, is that there are adaptations and creations, this relates to Professor Katz's point, that are being, the moment of constitutional writing occurs in the 1770s, 1780s, and they're thinking of this, these separations in different ways. And so Madison is building as much on that tradition, that American tradition, as on Montesquieu or others, but I'd be happy to look into that further. It's a good idea.
Please.
Hello, I'm Ron Weich. I'm the dean at Seton Hall Law School. I'm not a Federalist Society member, but I appreciate Leotis inviting me to join you. And I want to pick up on something that Professor Katz said at the end of her rebuttal and direct it as a question to Professor Bamzai, and it's about the president's veto power. Do you acknowledge or concede that it's significant that presidents, through the decades, signed the legislation that established these agencies? And it would feel different, I guess, if Congress passed a law, a president vetoed it, and by a supermajority, the Congress overrode the veto and said, no, this is how we're going to do it. But here, it's the and I'm happy to hear if there were such instances. But my understanding is that in all of these cases, or at least most, the Congress has passed a law, the president looked at it and said, yeah, I can live with this limitation on my removal power. And so, it's an accommodation, it's a settlement, as Professor Katz said. And I'm thinking about an agency where I worked years ago, the U.S. Sentencing Commission, which is a very, very weird constitutional structure, a judicial branch agency, different, parties represented. And in Mistretta, the court says it's weird, but Congress thought it would work, and the president signed it, although in that case the president did have a different interpretation, but still it survives as that weird structure. Isn't that how we should understand this constitutionally?
I think this relates to the bigger question, which is, do we ordinarily have judicial review for constitutional questions? Even though at some earlier point, we've had presidents who've had different positions with respect to all kinds of, rights-related issues, First Amendment, Second Amendment, et cetera. And if a president signs a law at time one, we don't think of that as somehow necessarily binding some future judicial review of that topic. And then the question would be whether it's any different in the context of removal or any other executive power style issues. So, if we have a president who signs away the veto power somehow in a blatantly unconstitutional fashion, would that mean, or the pardon power, would that mean that there is, at time 2, when the courts review the question, no pardon power because it was signed away at time 1? I would say no. So I think that it then circles back to the question whether there is such a power at all.
Thank you.
Professor Katz?
I agree with the premise of the question. I guess I'll just add a little. I mentioned the Sinking Fund Commission, and this is again an early commission designed by the framers. 5 members, includes the vice president and the chief justice. Professors Bamzai and Prakash have written about it. So the president conceivably could fire 3 members of the commission, but not 2. Is this executive control? I think either way, the point is this is a multi-member commission with actors the president cannot fire. It was designed by Alexander Hamilton, sort of the original presidentialist, and this was not conceived to be an impermissible intrusion on the executive power. I think we can contemplate the president continuing to exercise the executive power, right, which is the power to execute the laws on the book with the existence, even with the existence of independent agencies. And again, if Alexander Hamilton didn't have a problem with an agency like that, I don't either.
Can I say a thing about the Sinking Fund Commission, or I'll happily tack it on to the answer to this question, whatever it might be?
Let's get the question out, because this will be our last question.
Professor Katz made the point that 2 out of 4 types of officers couldn't be removed even by the king, and you addressed, I think, one of those types in the Q&As. What about the life tenure appointments, that even the king himself couldn't remove those officers?
So if I will, I'll just tack on my thoughts about the Sinking Fund Commission. This is a very interesting entity, and people should look it up and have a review of the materials that are out there on there. Some very interesting scholarship that's been put out on this topic over the last few years, for sure. And I think that where I would pick up is with Professor Katz's point that it's actually the presidentialist Alexander Hamilton who writes the proposal to create the Sinking Fund Commission. The Sinking Fund Commission then is enacted into law, and we don't know exactly what people's constitutional perspectives were with respect to the commission. But one reason why we might not read it broadly to mean that the Chief Justice could be set up as the head of a commission to run the Department of War or the Department of State is because Alexander Hamilton wrote the bill, and he was, as is known, at the time, a proponent of the executive power vesting clause provision. So that's perspective. So that's one reason. The other reason is that there were, in fact, 3 cabinet members who were on the commission, so it was controlled by the president in that sense. One does wonder whether the creation of the commission, which is in 1790, related to the set of topics that ultimately get litigated in the Haberns case about whether types of authorities could be conferred on judicial officers, could be related to that. And then it's not entirely clear, although this never happens, how removal worked with respect to the commission. So I think the way I would put it is that methodologically I would interpret the Sinking Fund Commission as a precedent, but just a narrower precedent than others have taken it to be, which is that you could just set up the Chief Justice to be a commissioner with respect to any commission out there in the federal government. And then I'm sorry that I've reached your question so late in my answer, but I think that life tenure as well with respect to executive branch officers would be problematic for many of the same reasons that I've previously discussed.
Any thoughts on life tenure for executive branch officials?
Well, I guess what I'd say is that this sort of English precedent sort of comes to us, and so I think there's a very fruitful line of scholarship right now that's coming out looking at states, looking at local officers, right, surveyors of roads and things like that. And I think that our sort of English inheritance is really shown there in the tenure of these officers, again, who might have served for decades, right? Once you were in, for most people, you were in until you died. And again, I think as a nation, we come to the realization that this is a bad way to build public administration. And so we continually pry ourselves away from that. And so I think there's genuine scholarship to be done about this common law of offices and at what level of our government we see it. But I think that the practice suggests that that's the background that we inherited and that officers, presume to have these jobs in some cases for life.
Okay, notwithstanding that Anthony signaled me, Lee, this is your show. So,
Oh, I just figured that if I had time, I would use this for a question, but if I didn't, I would use it to announce what happens next. I think we are, in fact, out of time. What I was going to ask about was the horizontal, necessary, and proper clause, but I'm not going to ask about that. Instead, why don't we say thank you to everybody. That was really terrific. And what happens next is that we are going to have several work in progress type presentations downstairs. There are 3 different panels that are going to take place at the same time, 1 floor down. And so take your pick. You can wander among the sessions also. We will reconvene in plenary fashion after that. But thanks everybody again.